Hello?
Oh, hi,
Hello?
Angie.
I can't, I'm trying to,
We're too close. Hello, am I getting through?
You are getting through. I would ask that everyone please mute your connection until your case is called. We'll be getting going. I'm just hearing everybody in. I want everyone to mute your connections. I keep hearing background. We have to have clean recordings of what is going on. I believe that matter you just filed into, is that correct?
Yes, Judge, I did just file my notice of appearance late yesterday. I was retained by the guardians in this matter, the Van Rocks.
Okay. All right. Is there anyone else appearing on that matter?
Hello, Your Honor.
Okay. And you are?
I'm his biological father.
Okay. All right.
And Your Honor, it's my understanding this was filed by mother.
And that's what I understood as well, and I don't seem to be getting a response.
I know it's early in the docket. I don't know if you want to give her a little bit more time. It would be my request if she doesn't appear that we just strike the matter.
Okay. All right, I'll recall the matter.
Very good.
Do I have
Thank
anyone appearing on that matter?
John Sasaki here on behalf of the father.
Okay.
Sherry Farr, the court visitor.
Gina Canoni, guardian.
So, Your Honor, I mailed up earlier in the week the agreed order that everyone has signed, the findings.
Okay. All right. Are you thinking that probably went through ex parte?
I attached a note to it asking them to present it to you for today.
Okay, here it is. The clerk handed it to me.
Perfect.
The most recent one, the second one looks like it might be an older.
Okay. All right. I do have, it looks like there are two. One that has the signatures. Let me see what this one. The clerk was indicating maybe the one on top was the newer one. It says page 1 of 7, and then the second one says page 1 of 14.
So I think only one has electronic signatures, and I put today's date. I hand wrote in today's date for the entry in there in the summary.
Okay. They both have it, and they both have electronic signatures.
I think it is only 7 pages, so.
Okay. All right. Well, that's the one the clerk was indicating she thought was the newer one. So I'll give back that one. So I'll sign off. Anyone have any objections to the signing?
No objections. And I can confirm it's a 7-page order with the signature page on the and it's 10 pages total.
Okay, so I'm having a signature on page 7 of 7. So it sounds like you're thinking that might be the one, or
Unless Ms. Barr has added any other pages. That's the copy that I have. Am I not mistaken, Ms. Barr? There's 7 pages on that.
It's 7 pages with the signature should be on the 7th page. Then there's the 2 pages. There's the confirmation page with the signature tracking, and then there's 2 pages after that, which is required to be attached, which is the instructions for notifications.
I signed that, so that should be
Okay.
Okay.
That sounds correct. Thank you.
Okay.
Sorry about that confusion.
I'm hearing some background that you're going to need to mute, so I don't. It sounds like a television, maybe, or.
Oh, it's probably me. I've got baby up, so.
Okay. That's fine. Don't worry about it. Okay, I have signed off on the order.
Thank you, Your Honor.
Thank
Thank you, Your
you.
Honor.
Thank you, Your Honor. Now, will I get a copy of that?
You'll
Or do
have
I-
to obtain it from the Superior Court Clerk's office.
Okay.
So, yeah.
Okay, thank
Okay.
you very much.
All right.
Bye, thank you.
All right. Who do I have appearing on that matter?
Your Honor, Curly Bliss on behalf of the minor Kayla Randall.
Kurt Anagnosio on behalf of the mother, Danielle Jones.
And Sherry Farr, guardian ad litem.
Okay.
Vicky Jones, temporary guardian of Kayla, representing self.
Okay. Anyone else? Okay. All right. So my question is, what is the status of the guardian ad litem report?
Your Honor, I have, the report is completed except for I still need to have a phone call with the counselor. That is the only thing, only item outstanding. And then I can get my report sent up.
Okay. How much time are you thinking?
I'm trying to get a hold of her this week. So I'm thinking 2 weeks with mailing time.
Okay. Anyone object to setting this over 2 weeks so we can get the guardian ad litem's report?
I would like to be heard with regard, I don't mind the set over, but we need to talk about some visitation.
Okay, just a second here. Let's see, we're on 11th, 25th. And remind me, Mr. Anagnostou, who do you represent?
I represent the mother, Danielle Jones.
Okay. All right, go ahead, Mr. Anagnostou.
Well, this is a case that since, I'm going to say since at least October or November, the court has been ordering visitation, some kind of contact between my client and the child, and it has still not occurred. She has had no contact with her daughter. She wants to talk to her daughter. And if the guardians can't make that happen, then they're inappropriate guardians. So we're here. You have ordered two different types of visitation to occur. One supervised by a party that we agree to, and then visitation happen kind of on an as agreed basis. And the other one is reunification counseling. My client has participated in the reunification counseling. She still hasn't got to talk to her daughter. And the other visitation about having somebody supervise it has not occurred. They won't come up with any person to supervise a contact. My client is willing, she's suggesting the petitioners has adult children, so it's the nieces and nephews. They're adults. They've indicated a willingness to help my client. We need to get some contacts set up. My client wants to talk to her daughter.
All right, so anyone else that wants to speak to this? Ms. Farr, do you have any thoughts?
Your Honor, so that the reason that I was appointed was to look into the visitation and whether the visitation and reunification should actually occur. And that has been the only focus of my investigation. And the last piece in it is for me to talk with the counselor. I know that the mother has not been in contact with me for a while. She was supposed to get back with me to give me some information about her, where she was moving to and her job and other things, and update me on the status of the reunification that she was supposed to be setting up. And I only had information on the initial appointment, and she hasn't reported anything to me since then. So I don't have information about even where mother is at in that process. And I need to talk with the counselor to see what the counselor recommends is best for the child.
And Your Honor, if I may be heard.
Go ahead.
Kayla has made it very clear from the very beginning of this matter that she does not have a desire to have contact with her mother. Again, knowing mom does have a constitutional right to have visitation with her child, Your Honor has made very, very many different rulings in this matter. And I think Judge Warning made it at the last hearing. Reunification counseling needed to happen. We needed to have both my client and mother in a controlled space with a counselor so that my client felt safe, that they could begin to build or repair the fractured relationship that they had. I understand mom's wish to have contact, but my client is adamant that she does not want contact with her mother. It was my understanding as of the last hearing with Judge Warning is that Ms. Farr was going to investigate the reunification counseling, that reunification counseling would begin, and it's my understanding it has, at least to some capacity. I don't think at this point ordering any additional visitation is appropriate, at least until we have, word from the reunification counselor and from Ms. Farr.
So basically,
Hold on, Mr. Anagnostou. Anyone else want to be heard on this matter?
Yes, Your Honor. I just wanted to reiterate that Kayla is on our behalf refusing to meet with her mom. She's 16 years old and 8 months, and we're doing everything we can to assist in that. But we cannot force this child to do something that she is refusing to do. And part of us being here is with Sherry Farr is to try to create a situation in which is best for Kayla.
So, Ms.
Thank
Farr, thank you. Anything else?
can I respond, Your Honor?
Just a moment, Mr. Anagnostou.
Yeah.
Ms. Farr, my question I guess I do have is, has counseling actually started for the reunification?
My understanding is that the mother went to the initial visit to set the counseling up, and I have not received any information that it's gone further than that.
Okay, all right. Mr. Anagnostou?
My response is, potentially what they're doing is asking for a modification of your rulings as well as several other judges' rulings that visitation is to occur. If they want to bring a motion to modify, those are the court's rulings at this point. They're just violating them. They're just saying, the court has ordered two different types of visitation, one phone call contacts or supervised contact with the supervisor that they arrange, and reunification counseling. And they're just saying, well, the child's saying no, so we're not going to do it, in direct violation of your orders.
So it sounds like we have a couple of different orders that have been in place. And part of the problem, I don't see any actual order other than a verbal order as to visitation. And I'm just looking here to see if I see anything, and I'm not, just to get it clear. And that's part of the problem is when we don't have an actual order like we may have in a domestic case, it makes it complicated to follow through and have that. That said, I understand the issues that the guardians are having when you have a child that's almost 17 and they are refusing to do something. And I'm interested in finding out whether or not mom has even followed through with the reunification counseling. And if she hasn't, I mean, she needs to do her part as well. And so that's a real issue too. And I understand the frustration, Mr. Anagnostou, that you may have. At the same time, we're missing information. And until we have that information, there's not a whole lot that I can rely on and do. And so if reunification counseling was ordered and we find out mom has not done anything other than the initial setup, well, I'm not going to be someone forcing a child to do something more than her mother is doing herself. So at this time, I'm not going to rule anything further. What orders have been made have been made. The only thing I can suggest, Ms. Jones, in regard to your part of it is if there is to get something arranged, set up an iPad or Zoom and leave it to the child to have that contact. And if they just don't, there's not a lot you can do to wrangle a 16-year-old or almost 17-year-old to sit in front of an iPad if they just refuse. That's where that reunification counseling comes in, which goes back to mom and whether mom has actually followed through with things. We don't have that information unless you know something, Mr. Anagnostou. Do you know whether she's done more?
I know she has gone through the initial interview, and per your order, it was to be conducted by a intern to save costs. And then the intern has to report that to Miss Rosen, and then Miss Rosen does whatever she's going to do. So it's in process, and she's cooperating with reunification counseling. But it's in process. And the other piece of it is, I guess, if Kayla doesn't want to talk to my client and you've ordered the guardians to have a visitation, I mean, I think Kayla tells my client that. Well, why can't she have a phone call with her, talk to her daughter?
Well, I don't know everything that's gone on between the daughter and the mother. It can be complicated, and in many ways, if you force a teenager to do something like this, can actually be more harming to the relationship than if the proper process goes through and happens, the reunification counseling, where the counselor can work with that child and figure out what's in the best interest of that child to work toward a relationship that obviously is broken. And if it's broken, again, to force a child to do that, that child, especially at that age, is going to probably grow in more hate and whatever emotion is going on there. I don't know what it is. And so at this point, I'm not going to force it. I think, Ms. Jones, you can do, what you can do. And I don't want to minimize that it's important to try to move forward, but at the same time, we've got to do it at the pace and at the rate that the reunification process needs to happen.
Your Honor, I can tell you that the mother has texted the child and the child refuses to answer. I do know that. The child is just absolutely refusing. She doesn't want contact. And I also don't see the mother on this Zoom. Is she present?
I'm not aware of her being on here.
Yeah. So that's a concern.
She got a message to my staff that she's having issues logging on.
Okay.
So I assume she's watching it by the other method.
Okay. Okay. All right. So with that, I think that's it for today. I'll set the matter over 2 weeks for the guardian ad litem to get a report. Hopefully, if mom has not been following through with the reunification counselor, that Mr. Agnosio encourage her to do that. And then meanwhile, we'll go ahead and set this on to April 25 at 10:30 a.m.
Good morning, Your Honor.
Thank you.
John Sasaki for father.
Fred Agnostiu for petitioner Marion Barrett.
Don Lisa for Georgia Woldridge, the mother.
Sherry Farr, the guardian ad litem.
Michael Erickson, the father.
Okay.
Georgia Woldridge, the mother, and I need to please excuse me, Your Honor. I need to acknowledge my wrongs, and I'm so dreadfully sorry to the court, my family, but most importantly, my son, Mickey Flynn. I love him so much, and I need to repair a relationship. I allowed terrible behavior from myself and his father as my son watched in horror, which is 100% not okay. I was not doing the right things, which over time I've worked on bettering myself to be the best mom that Flynn deserves. I love my son very much, and I need to be able to repair my wrongs for my angel, Flynn. Thank you for your consideration, time, and efforts, Your Honor. Thank you.
Thank you. All right. So at this point, the question is, what is the status of the reunification counseling?
Mr. Erickson had a phone call with the child yesterday, and the counselor, the reunification counseling the mother was supposed to contact them. She hadn't, so they actually tried to contact her. There's been no contact with the mother with the reunification counselor, which is Miss Rosen's organization. But the father has set it up, and he had a phone call yesterday.
Good. Okay. Anyone else?
I don't have anything else on the reunification matter. Thank you.
Your Honor, I haven't been able, this is Don Esau. I haven't been able to speak with my client. Her number has changed, and it's been since January since I've had a chance to speak with her. Had no idea she was going to be making a statement today. But I would need time, another set of her to get in contact with her and figure out what's going on with her.
All right, so Mom, it's really important to reach out to your attorney. You do have an attorney, and I appreciate your statement, but you really need to talk to your attorney and get your legal advice and direction as to what you need to do.
I respect that 100%, Your Honor, and I have emailed him and I have called him. He has my new number. We've talked on my new number. We have emailed on my new email because yes, we have, and I'm not getting any paperwork. I didn't get anything about the reunification counselor. I'm going through my email right now. I definitely didn't. I'm not missing it. No.
Who is it you're talking to? What attorney are you talking to?
Dawn, my attorney.
Mr.
But I haven't gotten any emails back. And it was ever since I changed my phone number. We talked on the phone twice since I've gotten
Okay.
phone number,
Okay.
and I've emailed him.
Stop. Okay. All right. Mr. Esau, will you be available this afternoon by chance?
Yes, I will.
Okay. All right. So Mom, and I apologize for calling you Mom. It's just easier to keep these cases straight. Would you please reach out this afternoon and talk to him again, please?
Yes, Your Honor.
All right.
And Your Honor, I have not had contact with Mother either for several weeks, maybe even a couple months.
Okay. All right. Do you have Ms. Farr's number?
Yes, I can find it. Yes, I can, Your Honor.
Okay. Very important that you reach out to the guardian ad litem, okay?
Yes, Your Honor.
All right. So do that this afternoon too.
Yes, Your Honor.
Okay. So with that, counsel, what's the plan, or what are you thinking for next steps at this point? Just continue with the visitation as present, or what?
Well, yeah, I guess that would be my suggestion, that we set this out a month and allow the reunification counseling to have more than one visit and see how they go, and then get that information to the guardian ad litem to see what ultimately the recommendation is going to be. It's my understanding, my recollection, they get one phone call a month. So that would, I mean, maybe we need to set it out for 2 months and get a couple of reunification counseling sessions done and see where we're at with regards to the parents. See if, I mean, to date, the mother has not participated and the father is trying.
All right, counsel?
Alternatively, if we could increase the frequency of visitation to at least twice per month or once every other 2 weeks, then I think that might help truncate the process.
Let me ask Ms. Farr, what are your thoughts in regard to that?
My only thought is that it's a financial burden on the parents. So if the parents wish to incur that, then I think that would be appropriate.
Okay.
And so we had the one visit telephone call with the father yesterday, and then the child has a counseling session next week with his counselor to see how this all impacts him, you know, whether good or bad.
And that's how it's gone. So the child goes to his own counselor every other week, and then he has the one phone call the week in between with mother, supposed to have the one phone call, and the other phone call the fourth week with father, so that the child has counseling with one or the other counselors every week. But the reunification, my understanding is, it's being paid privately by the parents.
Excuse me, please, Your Honor.
Oh, hold on. Just wait, please. Mr. Sasaki?
Yes, I believe what Ms. Barr mentioned is correct regarding that. Well, actually, I know it's correct that parties are paying for their own reunification sessions, which I believe are about $50 per session. And just working and thinking about a solution, if the mothers and fathers weeks were to run concurrently to land on the same off week as the child's session with the child with the counselor only, then I think that might help solve the problem in getting more sessions in prior to the next hearing.
Teresa?
Thank you, Your Honor. I would concur with Mr. Sasaki. That sounds like a reasonable idea, and I think my client would take advantage of that if that is made available.
All right. So, you know,
excuse me, please. If I could say
you're
one thing.
represented by an attorney, ma'am. All right. I can't just keep letting you talk because you want to talk.
I haven't spoken with my son since November 17th. I have not been getting a once a month phone call.
Okay. And I asked
And I've
you to
reached
talk.
out.
Stop.
Yeah.
Stop. I asked you to talk to your attorney this afternoon, and that's part of what I want you to get set up is that ability to have that conversation. So, and he was just asking for you to have increased time with that conversation.
Yes, Your Honor. Thank you.
Okay. So with that, that sounds appropriate. And, you know, it will be at the parent's expense. But you can go ahead and increase it as requested.
I was wondering, Your Honor, if we could just briefly hear from my client. I think she might have information with basically with scheduling. We want to make sure that we can schedule these.
Okay.
Hi, I'm Marion. I am Flynn's grandma, guardian at this time. He is really, really emotional after speaking to his parents and talking about him or talking about them during his counseling sessions with Christina Floyd. That's the counselor that he sees for himself, not the reunification counselor.
Right. Go ahead. The suggestion is that the parents would have 2 visits a month in between the counseling sessions with.
Yeah, I just the emotions that's gonna do to Flynn. I don't think that's in his best interest at this time. I'm sorry.
Ms. Farr, what's your thought?
Yeah, I understand what Ms. Barrett is saying, and I do know that it has affected him, which is why we established the 1 visit with the parent per month, which mom has not participated in. So it has been only started with dad. I mean,
if
I would suggest that we stay with that plan for now, because until I can talk to the counselor.
Mr. Erickson, stop.
Okay.
I would suggest we stay with that plan until I can talk with the counselor that Flynn sees individually and see how this is affecting him.
All right, let me do this. I don't think it necessarily needs to be back for a review hearing. I would like Ms. Farr to go ahead and have that conversation with the counselor. I understand it's going to be emotional. I understand it may be hard. At the same time, that's what he needs to, the child needs to work through as well. So what I would ask is that Ms. Farr make that contact, and then if Ms. Farr, after talking to the counselor, feels that for the child that would be okay to increase it, then I'll go ahead and approve the increase. If not, and it's just too much on the child, then we need to just leave it as is. If you want to set a review in 2 weeks to come back and do it, we can do it. But otherwise, that's where my thought is.
Thank you, Your Honor. I'd be okay with setting out to 2 weeks to hear Ms. Farr's discussion and opinion on that.
Okay. All right.
And I would suggest that we set it out a month so that we could have at least a couple of phone calls, at least with the father and potentially, hopefully, with the mother if she starts the process.
So here's what I'm going to do. I'm going to just set it over 2 weeks so we can hear from Ms. Farr, and then I have something solid to determine whether it's too much for the child to have that contact, to increase that contact for now. And then at that time, Mr. Anagnosto, I do think it's appropriate to go ahead and set it out maybe a month or 2 and let some of that visitation occur.
Right. Okay. Sounds good.
Okay.
Silence down. Where's medicine?
Okay. That's it for today.
Thank you.
Anna
you.
Cowden, attorney for petitioners and emergency temporary guardians.
For the father, Jack Carnahan.
Donald Esau for the mother, Katrina Vorse.
And Your Honor, Casey Looney is also present on behalf of the state. I'm having network issues today, so I'll have to leave my camera off.
Okay. All right.
And Katrina Vorse.
What am I'm hearing back noise that needs to stop. Okay. All right. So I did review the Guardianship report. So at this point, where do people see that we need to do as far as next steps?
Your Honor, petitioners are requesting today that the full guardianship be granted. There are a number of concerning issues that have arisen since our last hearing. However, as far as the guardian ad litem report, we do not have any formal objections. I do want to clarify on page 5 of the report in the summary, the guardian ad litem notes that there's a concern about the Mr. and Mrs. Vorse being permanent guardians for Jessica. The clarification we would like to make is just that they are both of retirement age and have concerns like anyone would that they will be in good health for the next 20 years. They are fully committed to being her guardians and want to do so for as long as they are able to. They're in good health and are more than willing to be her guardian for as long as they are able. As far as other concerning things, Katrina Vorse and Jack Carnahan have continued to make filings in the case without their attorneys. I also wanted to bring to the court's attention that there was a summary judgment order signed by Judge Evans on March 27th outside of this case, in which it appears they changed the child's name. We're a bit frustrated, I suppose, that these filings continue to occur without the assistance of the appointed attorneys. We haven't gotten service on any of these things that have been filed. We were not aware of this summary judgment order at all until I did a search in the process of preparing for today's hearing. Mr. Carnahan was appointed an attorney. You had previously requested that he file something to prove his paternity so that we could discuss the appointment of an attorney for him. To my knowledge, nothing has been filed to that effect. We have not had a visit done. We have not been provided a clean UA by the mother, even though petitioners have made efforts to make visitation possible once that is provided. We've been in an emergency temporary guardianship now for 157 days. And we do not see any reason that the full guardianship cannot be granted so that we don't have to continue to come back to court, as it is a drain on resources. On the subject of resources, my clients did make an effort to seek some financial support for the care of the child. And it was discovered that Katrina Vorse has been collecting that support even though she has not been in the custody or has not had custody of the child since November. We therefore request that the full guardianship be granted today.
Mr. Anagnostou?
Yes, Your Honor. It is improper to grant the guardianship. To get a full guardianship, they would need to do a docket notice on the trial assignment docket, the universal trial assignment docket, get this assigned for trial. This is not a default case. My client has responded to the allegations, and so from that point, we would need to have a trial so that witnesses can appear and testify on behalf of the parties, the parents, and guardian ad litem. I mean, it's inappropriate to grant a full guardianship when there's been a response and an objection, and the matter is being litigated. So if counsel wants to grant a full guardianship, she needs to do a docket notice on the universal trial assignment and get this assigned for trial so we can go to trial on the issue of whether this guardianship should be granted. With regards to the other allegations, they can't continue for some reason to raise this issue with regards to paternity. My client's name's on the birth certificate. He's listed as the father. So he's got to get a blood test to prove that he's father when he's on the birth certificate. I just never heard of that. But that's my recollection is my client has filed the birth certificate that indicates that he's the father of the child. If they want to challenge, I don't know how you would challenge paternity. Some third party come in and say, no, we're going to set that aside. I mean, I guess if they have a blood test from somebody else that shows up that they potentially are the father, we could get into some kind of dispute over parentage. It's not before the court. It's not before the court. What's before the court is my client is the father. He's listed on the birth certificate. And what he wants going forward is visitation. He wants to see his daughter. He needs to. We had submitted yesterday, he had brought in some reports. He is in full treatment. We've provided those to Miss Day. What we were here to request today is that the court set up, and what he's willing to do is paid for supervised visitation. Let's set it up with Miss Fellow's organization, you know, Reconnecting Families, or potentially finds another organization that does paid supervised visitation. But he wants to see his daughter, we need to get that. We need to get that going. So that's what our request here today is. He's responded to these allegations and needs to set up time to with his daughter, is willing to do paid for supervised visitation while he goes through the treatment program. He's provided the treatment information to the guardian ad litem, he wants to move forward, you know, protecting his rights as a father of this child.
Okay. Mr. Esau?
Thank you, Your Honor. I concur with Mr. Ignastu. My client has the right to a trial on these issues. She's contested the emergency guardianship at least 3 times, most recently last week, on her own. And she has a constitutional right to cross-examine the witnesses and to assert her parental rights. And at this point, she requests that this case be set for trial. We're not making any ground in temporary guardianship, that's for sure. And we need to move forward. My client has been doing some outpatient treatment. We don't have any UA reports yet, but as soon as we do, we're going to be asking for more visitation as has previously been set up. Thank you. I have nothing further.
Ms. Looney?
The state would have nothing to add this time, Your Honor. If we are setting for trial, we would weigh in on child support at that time.
All right. And Ms. Day?
Yes, Your Honor. Thank you. I would agree that the parents have responded and that this matter needs to be set for trial before granting a full guardianship. There should be a full hearing with witnesses, etc. I did receive information yesterday from Mr. Carnahan's treatment, which has included UAs and his beginning process of intensive outpatient treatment. I also received information from mother's treatment, so I know that she is in treatment, but there have been no UAs information provided as of this time. And the prior order of the court was that mother must have a clean UA and that visitation could begin. I have no objection to supervised visitation for either of the parents. I think that's appropriate. I would ask the court to consider an alternative to paid supervision simply because of the parents' financial status, that puts them in a significant hardship if they have to pay $50 to $70 per hour to visit with their daughter. They have not had any contact. Jessica has not had either parent since she's been placed with the petitioners, with one short visit with mom back in November. So I have expressed to the court a number of times that visitation should be happening, must occur, and we need to be able to move that forward. Mother has not provided the UA, and so that was the order of the court, so that should happen first, then mother. But we need to get this moving forward, and there does need to be some supervised visits start. This child is losing her primary bond with her parents as a result of what's happened in this court process, and we have to find a way through that for Jessica's sake.
Ms. Cowden?
We have not been served with any of the filings that have occurred over the last month. I am concerned that the parties will continue to try and circumvent both their attorneys and the court, as we have seen so far. I am also concerned about the summary judgment order that we were not aware of. I believe that had Mr. Esau or Mr. Anagnostiu been aware of it, they would have brought it to my attention. I have those concerns. I am also concerned About the issue of visitation for Mr. Carnahan, we had been instructed by the court to discuss his visitation as well as the appointment of his attorney at today's hearing. This did happen in between time. I do not want to have continued procedural issues draw this out more than is necessary. The child is doing well in the care of Michael and Carla Vorse, and the full guardianship is appropriate at this time. I think it was discussed in an earlier matter that the emergency temporary guardianships are only supposed to go as far as 120 days, and we are beyond that now.
So you said there was a summary judgment. I don't see one in here. When did you say it is?
It was signed on the 27th of March, and the case number is 24-08.
Okay, that's not on my docket, so I'm not sure what that is.
It was filed outside of this case, Your Honor.
It's a domestic case.
It's a summary judgment order. It has parentage next to the title. It does not acknowledge this case at all. It looks like what they were attempting to do was to acknowledge parentage. I will remind the court that the birth certificate that was filed into this case was reissued in December of 2023, I believe. And our concern had been that that was an acknowledgement of paternity.
Yes.
There were a number of concerns we had about what had occurred while the child was in the care of Mr. Carnahan and Katrina Vorse, and had wanted to allow the Progress Center to continue to work with the child and for the child to seek counseling. These things have gone on. It just seems frustrating for all of us involved, I think, that there can be orders going on outside of this case that affect what's going on here without it, I don't know, being served or known to us.
Okay, well, in regard to that matter, I'm not sure what to even say or do. I don't know how that could even be monitored other than what you're seeing. Whatever case may be happening, if you're not a part of that case, what is that now? People, please mute your connections until you are called upon, please. All right, so I don't know what to tell you on that at all. That's not something I can monitor, or I even have any ability to go, and orders not on the docket. If you need to bring a motion in a separate case, that I'll leave that to you. But as to what we have in front of us today is the minor guardianship. But I don't even know what's going on in the case to even know for sure what the court would even order. As far as, you know, Mr. Carnahan being the biological father, I don't know that there's been any proof at this time to say if he's on the birth certificate. I don't know what else can be done at this point other than bring it up at an evidentiary hearing. But to just come in with the idea, I'm sure the child is doing fine with Mr. and Mrs. Vorse. I'm not questioning that, but at the same time, this is about ultimately a return of the child to the parents in the long run, if everything is followed through. So even though it may be going well, and you know, for the child, that doesn't mean that that is necessarily the long-term what happens here. So there has to be the visitation that needs to occur, that's been ordered, and that needs to happen. So as far as, let's see, the visitation, let's see, with mom is to have the UA, that's to occur first, correct, Ms. Day?
Yes, Your Honor, that was the previous order of the court. Both parents are now in treatment, so
Okay.
I would not object to visitation moving forward.
Okay. So that visitation does need to move forward, and it needs to happen. In regard to the idea of just making a decision of granting the full guardianship, and do you have some authority that says that I can just do that? Because I just can't imagine anything saying that.
I suppose the concern is just that the emergency temporary guardianship just is continuing to go on and on. If setting it for trial is necessary, then that's necessary.
Okay. It needs to get set for trial so parties can be heard of whether a full guardianship needs to occur, that the parties have a right to have their counsel present. So that's what needs to happen. It needs to be set for trial. So two things. One, the visitation needs to occur and as recommended and ordered. And then two, the matter needs to get set for trial.
Your Honor, would you like another extension to be entered while we're
I
waiting?
do. It does need to happen.
Your Honor, can we have something in the order that indicates that the visits must happen with a certain frequency, some sort of way of moving this forward, because it's been ordered and it just isn't happening. I would ask that we have maybe 1 or 2 hours supervised. We can come up with an agreed supervisor and have a date certain that this starts.
Ms. Cowden?
I would agree with that request, Your Honor.
Your Honor, we have agreed to supervisors. We've already discussed who they are, and that has been agreed to. We also did have in our prior orders a frequency listed. I need to refresh what it was.
All right. So that's been done, Ms. Day, I think. I don't have it sitting right in front of me, but I was pretty sure it'd been done.
I thought it had been as well, Your Honor, but it just hasn't moved forward. So I guess my asking at this point is, now that both of the parents are in treatment, can we start with visits this week for both parents based on that order?
Okay. It needs to happen, bottom line. And again, as guardians, that means that you also have to participate in and be available for the visitation to occur. So that visitation needs to occur.
And Your Honor, we have made efforts to be available. The order that has not been fulfilled is the clean UA aspect, which we have been waiting on the mother to provide to us prior to visitation per court's order.
And that does need to happen. Okay. All right.
Well, that's an issue, Your Honor. My client has provided UAs to his treatment facility, and they show positive for drugs, but he's in treatment and working on those issues, and should be allowed to have supervised visitation while he's going through that process.
Okay. I've already ordered on this. I'm not going to change what I've already ordered. So I expect a clean UA when visiting that child.
Yeah.
Okay. So set it for trial.
Thank you, Your Honor.
Thank you, Your Honor.
The mother.
All right.
Tina Day, guardian of life.
Rebecca Beck, petitioner.
All right. So the guardian ad litem report is in, recommends child remains with the petitioners. I wasn't real clear whether or not the parents had been served. So that's one of my questions.
Yes, mother has been served and father was served last month.
Okay, you need to file your affidavits of service.
They were filed last month, Your Honor.
Do you know when they were? I don't see them.
Yeah.
There was an order to allow service by mail on March 4, and then there was a court hearing on March 7, and an order extending, but I don't see actual affidavits of service that service has occurred.
I believe the father was served March 8th, if my memory serves me correctly.
Okay. I don't have anything in the file that shows that. So,
Excuse me, Your Honor. I spoke with him recently and he had told me that he had not been served.
okay.
He was served at his last known address.
All right, so you need to file your affidavits of service. They're not in here. Okay. So that said, so what I wasn't sure about is whether or not, in regard to the parents, let's see. So we have mom on here, but we don't have dad. Is that correct? Or do we have dad on here?
We just have mother, Your Honor.
What's that?
It is mother only on the hearing that I can see, Your Honor.
Okay, thank you. All right.
Your Honor, Miss Raleigh was ordered by the last judge to give us father's phone numbers. She gave us 2 phone numbers that were disconnected, and we've been trying those since our last court date.
Excuse me, Your Honor. I do not have very much contact with this alleged father because by DNA testing, he's not the bio father, but he is on the birth certificate. He just sometimes randomly shows up at my door, and I don't speak about a lot of things with him, but I did bring up, that this was going on, and he had mentioned, which was this last Sunday, that he had not received any paperwork. And so I don't have any other phone numbers, if that's
okay. All right.
what we're trying to get at.
So let me ask the guardian ad litem, did you have contact with dad?
No, Your Honor, there's been no contact with father. There have been multiple attempts at service. My understanding is he was served shortly after the last hearing at his last known address. There has been a court action in Multnomah County that was in process to disestablish him as father, but neither mother or father followed through with that process. So he remains on the birth certificate. He is the father legally, and proof of service needs to be filed so that we can move this case forward.
Excuse me, Your Honor, I am going to be moving forward to have that handled with the birth certificate.
To have him removed, is that what I'm hearing?
Yes, Your Honor.
Okay. All right. Well, meanwhile, I have to have service. If you don't have service, there's nothing I can do at this point. So
can we set it over 1 week, Your Honor, and that would give the petitioners time to file that proof of service and make sure that that's been done properly?
Yeah. Okay. So, yeah, Ms. Beck, I understand you think that it's been filed, but I don't see it. So regardless, you should file a copy and something that can show me that service has been made. Okay.
Absolutely.
I'm going to set this over 1 week to allow you to get that done. Okay.
Great.
Okay, Your Honor. Thank you.
And then Mom, if you would just check on what you're going to do on the paternity side of it, I'll leave that to you. Okay.
I will do that, Your Honor. No problem.
Thank you.
Thank you.
Who do I have present?
Counsel.
Your Honor.
Oh, sorry, go on.
Oh, Alice Harris, mother.
Josh Harris, father. And Your Honor, I am appointed counsel for Mr. Harris today.
Victoria Harris, mom. Oh, I'm sorry. Go ahead.
Victoria Harris, stepmom.
And Donald Esau for Alice Harris, the mother.
Sherry Farr, the guardian ad litem.
Okay.
The guardian is in the booth, but she is muted.
This is Maya Dean, Maya's grandma.
All right.
Your Honor, it looks like we also have Angela Brown, who is filed a separate petition.
Okay. All right. So I saw a notice of intent to move. This court did not grant any authority to move with this child or remove this child from the school in which the child has been attending. And so I'm not sure where parties stand as far as that goes.
Are you asking me, Maya Dean?
No, I'm asking the attorneys for the parents.
Okay, thank you.
Your Honor, again, Tom Lee, attorney for Mr. Harris, the father. When I spoke with my client yesterday, his preference is that, well, first with regards to the maternal grandmother potentially moving. He has some serious concerns about that naturally, and given Ms. Farr's report as well, that does raise some obvious concerns as well. With response, Your Honor, to your specific question there, though, I'll just kind of cover multiple bases in that my client, as the father, would first today at this hearing prefer that his first choice would be that the stepmother, Megan, be the appointed guardian, but alternatively, his mother, Mrs. Angela Brown, is an acceptable alternative as well. At the moment, just in the interest of time, that's where I'll leave it and turn it over to counsel for the mother.
Thank you, Your Honor. Donald Esau for Alice Harris. Her preference in this situation would be to object to the notice. We just received it yesterday, so and I think it was forwarded to us by the court instead of Ms. Dean, but certainly my client would object to that. Secondly, my client concurs with Ms. Farr's report, and she believes that Angela Brown would be an appropriate emergency guardian at this point, certainly if Ms. Dean is going to continue to move to Pendleton. But the child should remain here. Moving to Pendleton would be problematic for my client because she's disabled. I don't believe she drives, and she's trying to reestablish her connection with Maya, and having the child here in Cowlitz County would help facilitate her establishing more of a relationship with her child, and she is requesting visitation. Thank you.
So it's clear as to what occurred is I received the notice yesterday. I saw it, and I couldn't quite tell whether anybody had been served with it. So I wanted to make sure at least the parents had notice of it. And so I had my judicial assistant send it to their attorneys. That's what happened.
Thank you.
So anyhow, I think it was also maybe sent to Ms. Farr. I'm not sure.
Yes.
So anyhow, that's what happened as far as that goes. So with that, I need to find out from Ms. Dean, are you still planning to move to Pendleton?
Yes. I just wanted to let you know one thing, that I have everybody involved except for, the legal team has been aware that I was selling my house and moving, that Megan knew that when she asked me to, file the guardianship for Maya, which, I've had for 3 weeks. So doesn't really give me the 60 days of time, to inform everybody. And so if I'm not under consideration for being able to be the guardian for Maya, I had thought of taking Maya and Alice with me to Pendleton, because then that way Alice and Maya, would be able to work on their relationship and be under, close supervision at all times. In lieu of that, though, I also say that I think Angela is a good resource for Maya. I just hadn't thought of it because, she already has her other granddaughter, Serenity, with her, but it sounds like Maya would be able to, participate in the same, after school and weekend care that Serenity gets. And I have all of her appointments and everything that I've set up that I can pass along to Angela. Angela and I have a good relationship, I think. My only last question would be, if I'm not going to be considered, is Maya has a dog that Josh and Megan got for her, and we brought the dog with us when we picked up Maya. And so I'm wondering if there's anybody who can step up to take Maya's pet so that she's not, deprived of the pet.
All right. And then we have the other case as well, Ms. Harris.
Yes. Hi.
Your mom, right?
Yes.
I've got you confused. I'm sorry. I'm looking at a lot of faces. They don't have it lined out like they do a lot of cases. All right. So actually the stepmom is who I'm asking for.
Oh. Yes, Your Honor.
All right. Anything you wanted to say?
I don't object to Angela having guardianship, but I think that it would be in the best interest of Maya if Angela and I both shared guardianship of her. She has her own room here. You know, I got her signed up into softball. I'm able to take Maya to all of her functions and everything. And Angie Brown and I have had established relationships in the past where she has taken Maya just herself and there's not been a problem. And yes, we've gotten in fights where I had to put a timeout on us for a while where she could not see the kids for a while. But I don't think it's not in the best interest of Maya completely removing her from her home. And every visit that we've gone to, she has cried leaving, saying she has wanted to come home.
So, Angela Brown, I'd like to hear from you. How are you with the idea of being the guardian? And you're muted, just so you know. You're muted, ma'am. You need to unmute.
Okay, can you hear me now?
I can.
I'm sorry about this. I'm not techno savvy.
That's okay.
So I am excited that Maya could possibly come stay with me until Alice and Josh are capable to take care of her. Maya has been in my life since birth. I have no issues with everybody being involved. I think that's how it should be. It takes a village. I'm capable and I'm able and I'm willing. I do have a 5-year-old living with me at the moment. I have 2 beds in that room. I have bars on the window because I have my grandkids all the time. It's a safe place. And as far as what Megan was saying, that was one of my questions that I actually did have for you today is for a supervised visit that is stated in the paperwork, Maya's in softball and I'm not going to always be able to take her. And that's something that Megan has been doing with her. Would that be considered supervised if she's like in an open area with other kids and her siblings and that type of thing? Because solely I want to do what I'm asked of through the court. This is my first time having to do it this way. So I'm a little unfamiliar with the right and the wrong way.
So we'll get back to that. And I
Okay.
guess my one question is on that, is whether or not, it sounds like there's a dog involved. Are you willing to take this dog there?
So I live at the Monticello Hotel and they do not allow dogs. You can have cats, but I've already told Maya that unfortunately, if I could, I would, but the management, no. So, and I reached out to family members and nobody can do it either. So I don't know what to do about her dog.
Your Honor, the dog would be coming back to our place of residence.
Okay.
Actually, Your Honor, the
Thank
dog
you.
would not.
Hold on. I'll get there as soon as I can. All right, I'm not going to make this, it's not a court hearing regarding the dog, okay? So if this is a dispute between Victoria Harris and Joshua Harris over a dog, I'm not going to make, that's not in front of me. I'm not going to do it. So you'll have to figure out where the dog's going to go. All right, so is there anyone else that wants to be heard as, and I'm not talking, if you're represented by an attorney, you have an attorney, let your attorney speak for you, but is there anyone else that I missed? Okay.
Your Honor, my only input would be that I don't think that a co-guardianship would be appropriate.
Okay. All right. So with that, I am going to appoint Angela Brown as the emergency guardian at this time. If the parties want to consent and get to that point of papers, that's up to them. I'll leave that to the attorneys. But I do, with the current guardian moving out of the area, it would not be appropriate to take the child. So with that, Angela Brown will be the guardian for the child. Ms. Dean, when is it you're looking to leave?
Our house was supposed to close today, but there's been yet another delay, so possibly next week. And so that would take us to the middle of May as a move date.
Okay. So I want the move of the child this weekend. I want to get it done so we don't have something last minute. So the child will move to Angela Brown's by Sunday at 5. And get any clothes or whatever it is that needs to get taken to Miss Brown's, taken over there. And then, like I said, in regard to the dog, I'm not going to make an issue in regard to that. In regard to visitation, Ms. Farr, your thoughts on that?
Your Honor, there's several people involved. Everyone except Miss Brown has some serious issues going on, and I think that everybody's visits should be supervised in some capacity.
Okay.
I know that it's important for the child. The child has a connection with every one of these people. It's important for that child to have time with her siblings, time with all of the parties involved. But I do think because of the drug issues, the mental health issues, the lack of following court orders, there's all kinds of issues involved with everybody that there should be supervised for everybody. I would say though, it sounds like there is the softball games that Megan is offering to provide transportation to and from. I guess maybe that would be an exception.
Okay. All right. Mr. Lee?
I need to consult with my client, but we take the weight of Ms. Farr's recommendations very seriously.
Teresa?
Yes, Your Honor, my client would like to have visitation. She's currently, I received paperwork today, which I haven't been able to share with anybody yet, but she's involved with the CODA program over in Portland. She shows up every day for methadone treatments. Her UAs have been positive. I mean, I don't mean positive in the sense
what you meant by that.
Okay, good. Thank you. Yeah. So she spends the majority of the weekdays in Rainier, and then she.
Scappoose.
Oh, I'm sorry. That's right. Scappoose, where the candle is, of course, and the weekends in Beaverton. So she would like to have visitation on a weekly basis for a couple of hours at least. The last visitation that she had was from like 9 o'clock in the morning till 5 in the afternoon. And that I think that was just here recently, about a week ago. Certainly she would take that if it were available to the court. And obviously, since she doesn't drive, she would have to get transportation there. She has a good relationship with Miss Brown. They possibly could just do the visitation there, and then Miss Brown could supervise if she's agreeable. At 9 a.m. to 5 p.m. on a Saturday or Sunday would be great for her.
So, Ms. Brown, let me ask you this. Is this something you're willing to do, is supervise?
Absolutely. And I'm not available Thursday, Friday, and Saturdays. Those are the 3 days that I do work. So Sunday, Monday, Tuesday, Wednesday, I'm available to help with these relationships for Maya. Yes, absolutely.
Your Honor, if I may, I'd like to have some input on the visits with Ms. Harris, with Alice. And that is that there is a current parenting plan in place. The parenting plan allows mom to visit every other weekend supervised. But the parenting plan also provided that she provide an evaluation and some drug testing, which she has not complied with yet. She filed a motion for adequate cause to change that parenting plan. The hearing was yesterday. She did not appear for the hearing. So there is that family law case that is in conjunction. And I think that mom needs to, her visits need to continue to be supervised until there's some compliance with those court orders.
I didn't know I had court yesterday.
Okay. Well, so here's my thought in regard to this is, I do want the visitations to be supervised for each of them. That I wanted according to Ms. Brown's schedule. She has a work schedule. So I'm not going to be necessarily ordering full days, but at least 3 hours once a week for now with each parent. And if something can be increased because your schedule allows for it, then that I'm fine with that. The problem is the longer it gets, the harder it is to do supervised visits. So that's where I would not go too far beyond that 3 hours. Because it does get difficult that you're sitting there and observing and watching. And I don't know of many children that want to have that kind of supervision either. So at least 3 hours per week. You asked about the softball game. That's fine. It's open, it's public, as long as they're within sight. And that's really the test, is within sight. Okay.
So, but I wouldn't be there. I would be at work. That was my question.
Okay.
I wouldn't be there.
I see.
That's why I wanted to ask you how this works, because there's going to be times that she has a game or she has practice and I can't get out of just the small amount of days that I work.
Okay. Well, if you're working and you can't be there, then it won't happen. I expect you're the supervisor, and if you can't make it, then the scheduled time can't occur then.
Your Honor, may I say something?
Go ahead.
Maya's softball coach is a very nice lady. And if Angela reached out to her, I bet that one of the other parents would pick Maya up for practice. Okay. Or even the coach herself.
Yeah, I'll leave that for you and Ms. Brown to talk about those things. Okay. Okay. All right. So with that, let's get the change. Yes, Mr. Lee.
Yeah, pardon the interruption. I just had two brief procedural questions I wanted to address with the court. The first one, I just wanted to clarify that your ruling of appointing Miss Angela Brown as the guardian applies to both cause numbers.
It does.
Okay, thank you, Your Honor. And then the second question I had is, I was wondering if we could renote this matter even just for a review hearing in 2 weeks, just so I can consult with counsel and several other parties regarding the procedural issues here with having multiple cases and whether or not we can address appropriately how to, consolidate, if you will, the actions.
That's what I was looking to, everyone, is that one, I want to make sure that everything went smoothly in regard to the move, that the child gets settled and the visitation has started. So I'd like to set this out 2 weeks to see how everything is going. I'll go ahead and do the emergency order with the new guardian. And then we'll see how things are and then go from there.
Very well, Your Honor.
All right.
Your Honor, can I ask a question and then let you know some information just real quick?
Go ahead.
So my question is, I've never had to do a supervised visit with another person with a child. How does this work? Like at my apartment, can they be in the living room watching TV together while I'm off in my room? I don't have to be right there at all times, or do I? I don't want to be like hover on their time together. So I don't know what's right and what's wrong to do. I don't want to get in trouble.
So at this point, you pretty much need to have them within sight.
Okay. All right.
It may change at some point where it's not within sight. And that's why I said 3 hours is probably where you need to have it as a max for now.
Okay, yeah, because my ultimate goal is not to keep anybody from Maya. It's for all of us to love her and let her know that. So that's good. And then my other thing is I did talk to Sherry Farr about this. I have had a planned trip since December, and I'm going to be in California from the 21st to the 29th. And I've already made arrangements with my family to get Serenity to and from school and overnights, which is where she stays when I'm at work anyways, which is her great grandmother or her great aunt. So the same thing would be going on with Maya. I just wanted you and everyone to know that everything's already in good hands.
Okay.
And then the school thing. Do I need to have paperwork to go on next Monday to get her out and get things going? I don't know how this works.
So I'm going to ask the clerk here a question in just a minute, because we're having a switch. Does she need new letters or?
Yes, so I believe the petition that does not have any orders in it, you will be signing probably the immediate emergency order in that case, and then she can get letters issued on that order, and then the other case will just be, I don't know if we're going to consolidate it and then just not move forward on that case anymore.
Okay. All right. So I'll have to do some paperwork here this afternoon, and you'll get what are called letters.
Okay.
And those letters are what you take to the school and what you'll take to the doctors, would show you that you have the authority to handle these things.
Will those be mailed to me or they will be
No.
like on an email link?
You'll have to come in and to the Superior Court Clerk's office and ask for them.
Can I do that tomorrow? Would they be ready by tomorrow?
She has to bring her oath and the letters to be issued and $5 for the letters.
Okay. Did you hear that?
No, I'm not hearing her well.
Okay, you need to bring your identification. You need
Okay.
$5 and your oath. Where does she get the oath from?
I don't even know what that means. What's an oath?
Your Honor, I'll help her through all of those procedural
Okay.
things.
Okay. Thank you.
Okay, thank you, Ms. Farr.
Now, I'm assuming that I'll be staying on to help with the procedural things as a
Yes,
court visitor. Yeah.
Please. All right. All right. That's it for today.
Oh,
thank you.
Your Honor.
Your Honor.
Thank you.
Your Honor, this is for a separate case. I had came on, my son's hearing was for today at 10:30. I was having troubles logging on. It's for case number.
Okay, I'll just stop you there. Because you weren't here and you were the one making the request and I actually waited for a while and you didn't join. And so I have stricken it, which means I canceled it for today. You'll have to re-note it on, do another notice and serve the parties.
Okay. Like I said, I was trying to get on and I was just having troubles. I was only.
I get it, and we can only wait so long, unfortunately. Okay.
I understand, ma'am. That'll be fine. I will go ahead and do a renotice.
All right. Thank you.
Thank you.
All right. Is there anyone else that thinks that they should have had it matter?
Well, the father is on the line right now.
Okay.
We're all present.
No, you're not. So I've already stricken it. We're done.
Okay. Yes, ma'am. Thank you.
All right. That concludes this docket.